Hi, I'm firearms attorney Gilbert Ambler, and I'm back, unfortunately, because Virginia lawmakers are back at it again. They're filing anti gun bills, and today we're going to go through yet again what some of these bills contain that have been presently pre filed. We're going to talk through what they would actually prohibit, and we're going to try to dispel some misinformation that's floating around out there. I've heard some rumors about some of these laws and what they do or don't do that I don't think is necessarily accurate. We're going to talk through that. And one thing that we're not going to do today, which I think some of you might be curious about, and we just probably shouldn't touch just yet, is cracks or problems with the bills that have been constitutionally speaking, legally speaking, with the bills that have been pre-filed. Why are we not going to disclose what we sort of see as issues with these bills? Well, we don't want to give people in the government any ideas to fix these bills. We'd rather, in fact, if they're going to pass this sort of, for lack of a better term, stupid stuff, we'd rather it be passed with the problems. That way there are viable avenues to challenge these bills. So we don't want to give anybody any ideas about it. We're not going to be discussing where we actually see problems with Virginia's proposed assault weapons bans and the other various bills that we're going to talk about today. As always, by the way, if you have not yet hit that subscribe button, what are you waiting for? Hit subscribe, like, comment with your thoughts, share with your friends. That way you and your friends can keep getting these important Second Amendment updates. And before we actually dive into the merits today, quick reminder for everybody, January 19th, Monday, January 19th, Martin Luther King Day, Richmond, Virginia, VCDL, Virginia Citizens Defense League's annual lobby day. I hope to see all of you there. All right, so what are we up against now in 2026? The first one that I think everyone anticipated coming was the assault weapons ban. And of course, Virginia already has some assault weapons laws, but they're not nearly as onerous as what is being talked about right now. And keep in mind, what we're talking about today could actually get worse before it's passed, right? These bills can still be edited, they could be changed, there could be other versions filed. So the assault weapons bill that has been pre-filed. This is HB 217 filed by Delegate Helmer, and we're going to hear a lot about Delegate Helmer. He's going to be one of the ones who is repetitively seeking to restrict firearm rights here in the Commonwealth. What has he filed? So the first thing that the bill does is it generally allows individuals that are eligible to keep firearms and are over the age of 21 to keep things that would be deemed assault weapons, provided they were manufactured and possessed prior to July 1, 2026. In fact, if the item that was an assault weapon was manufactured prior to July 1, 2026, and this includes a list of weapons that we're going to go through, it's also going to include large capacity magazines or large capacity feeding devices. So your standard capacity 30 round mags for your ARs, your standard capacity 15, 18 round mags for your handguns. You're going to be allowed to keep them. You're, in fact, going to be allowed to still use them as you otherwise would, transfer them, etc. here in Virginia, provided they were manufactured prior to July 1, 2026, and you're not transferring them or possessed by someone who is under the age of 21. So, as currently written, a lot of people are going to breathe a sigh of relief on that basis alone. I don't want you to breathe too big a sigh of relief because, as I said, that could still change. Why might they have drafted the law this way? Although there have been other states that have actually drafted laws and passed laws and taken away firearms that people currently possess, I imagine that there is a risk that there might be some taking concerns, talking about like Fifth Amendment takings clause, and probably the law is drafted this way to avoid a takings challenge, to avoid somebody going to the government, going into the courts and saying the government's taking away something that I lawfully purchased. So what constitutes an assault weapon under the proposed law, HB 217? First off, we're going to limit this to semi-automatic weapons. And for the most part, we're going to limit it to semi-automatic centerfire weapons, with the exception of the large capacity magazines. That would include large capacity magazines other than tubular magazines for 22s, but it would include your standard magazines and belts and other ammunition holding devices that include both centerfire and rimfire when it comes to that particular ban. But the weapons itself, the types of bans that we're going to see, first off is going to be a centerfire semi-automatic, and that's the second component. When it comes to weapons, we're looking at semi-automatic. The law as drafted does not apply to bolt actions, pump actions, lever actions, etc. So we're looking for centerfire and semi-automatic. First category would be centerfire, semi-automatic, and with a fixed magazine capable of holding over 10 rounds. That would become an assault weapon. Second category would be centerfire rifles. Again, semi-automatic. And now we get into what we call the features bands. So if it's a semi-automatic centerfire rifle capable of accepting detachable magazines and it has any of the following features, that would be a prohibited assault weapon. So under this list, what we're talking about is any type of adjustable stock. So telescoping, folding, etc. Number 2 would be a pistol grip that protrudes conspicuously beneath the action of the rifle. A second hand grip or a protruding grip that can be held by the non-trigger hand. A grenade launcher, a flare launcher, a sound suppressor, a flash suppressor, a muzzle brake, a muzzle compensator, or a threaded barrel if it is the muzzle end that's threaded that would allow it to accept any of those attachments. And then they've also got kind of a catch-all provision, any attachments or characteristics of like kind as enumerated above. So again, this is going to be your semi-automatic rifles with just about any features that we see on modern sporting rifles are going to be assault weapons. Again, that's only if manufactured after July 1st, 2026 for those that are over the age of 21. So if it was manufactured prior to July 1st, 2026, under the law as written, as long as you're over the age of 21, it doesn't count as an assault weapon. How do we know whether something was manufactured prior to July 1, 2026? Well, serial numbers are going to help us decide that. If you own some items that you are concerned about proving you possessed prior to July 1, 2026, you could photograph those items now, time and date stamped photograph. You could even provide those photos if you wanted to hire a lawyer. You could even provide those photos to a law office, have a law office open a confidential file. That way it's not something that the government could go through your computer and find the files itself and use those pictures against you. You'd have attorney-client privilege, and it would be something that an attorney could maintain pictures of your weapons. We'd do that for a fairly nominal fee for people. So we have had people in the past want to be able to prove what they had at a certain point and want to open a file with our firm simply for purposes of saying, maintain these photos in your files. That way I don't have to keep them in my possession and you have them in case I ever need them for proof of something in the future. So that's something you could consider. The next category, this is going to be centerfire pistols. Centerfire pistols that accept detachable magazines. And then once again, we get into the features list, the features here. And the first feature that we're talking about shows how little, and I told you I wasn't going to get into litigation strategy, but shows how little they understand about what they're writing, because it's a pistol that centerfire pistol accepts detachable magazines and has some type of stock on it. And if you know anything about firearms, if it has a stock on it, it's no longer a pistol. It's now a short-barreled rifle, assuming we're talking about a pistol-length weapon, because of the attachment of the stock. So obviously, pistols without stocks, hopefully you already know this, you can't have pistols with stocks. That would become an assault weapon in Virginia. The other characteristics that we'd be looking at would be, number 1, a second hand grip or protruding grip that can be held by the non-trigger hand. The capacity to accept a magazine that attaches to the pistol outside of the pistol grip. A shroud that is attached to or partially or completely encircles the barrel and that permits the shooter to hold the pistol with a non-trigger hand without being burned. I guess if you do get burned, that's okay. A threaded barrel. Again, they go through what the threaded barrel could be capable of accepting: suppressors, flash suppressors, etc. Threaded muzzle, that's what they're looking for here. A forward hand grip or any characteristic. Again, we've got the catch-all, any characteristic as like kind enumerated above. So they're going after semi-automatic shotguns that have any type of folding, telescoping, or collapsible stock, pistol grips that protrude conspicuously beneath the action of the shotgun, and then any shotguns that accept detachable magazines, and finally any shotguns with fixed magazines with capacity over 7 rounds. So this is going to affect some sporting shotguns that we see sold. And then we talked a little bit already about the large capacity magazine feeding devices. This is going to be anything that was manufactured after July 1st, 2026, and includes magazines, belts, drums, feeding strips, or similar devices that have a capacity to accept more than 10 rounds of ammunition. So again, there's going to be lots of devices and lots of weapons that you will not be able to purchase if this goes into effect new after July 1st, 2026. You might still be able to purchase used weapons. What are the myths that I want to talk about? Well, I've had people contact me and say they've heard from other lawyers that you would still be able to, because long guns can be sold by FFLs to non-residents, that you would still be able to go to somewhere like Tennessee and buy an AR-15 with all of the features that would be prohibited after July 1st, 2026. You'd still be able to go to out of state and buy a new, because keep in mind, manufactured after July 1, 2026 would be prohibited, a new weapon. And I don't think that's true. I don't think that's true for a couple of reasons. Number one, because the law as written prohibits the import into the Commonwealth. Secondly, I don't think that's true because federal law tells FFLs, it's 18 U.S.C. 922b3, that they need to comply. Their sale to a non-resident of a long gun has to comply with what the laws of whatever state the purchaser resides in. So maybe if you maintained a dual residency, right? If you lived 6 months of the year in Virginia and 6 months of the year in Tennessee, ATF says you can have dual residency. In that situation, I think you could go to Tennessee and buy one of these weapons. But if you're a Virginia resident, I don't think you would otherwise be able to go into Tennessee, even though you could buy a long gun at an FFL in Tennessee. I don't think the FFLs are going to be willing to sell you anything that meets these definitions of assault weapons, and they might not sell you anything, period. I tell you, for the FFL, or I'll tell folks watching, for the FFLs I represent, I tell them, don't sell long guns to residents of states that have restrictive laws, because you don't necessarily know, if you're a Virginia FFL, what laws Illinois has in place. And you've got to certify, if you're selling a long gun to an Illinois resident, that the sale complies with the laws in Illinois. And I think it is unwise for you to sign your name on the dotted line in that fashion. All right, moving on. Let's talk about what other restrictions we're seeing coming. We've got Delegate Helmer once again asking the Attorney General to review reciprocity agreements. So looking to see what other states Virginia might no longer recognize for their residents to be allowed to carry in Virginia. That proposed bill would also, by the way, restrict people that are Virginia residents from carrying on another state's permit. So if you move here from Texas, you had a Texas concealed handgun permit, and took you 6 months to get a Virginia concealed handgun permit, you wouldn't be able to carry for those 6 months on your Texas permit. I always urge folks that move to the Commonwealth to get a Virginia permit anyway, to make sure that they're exempt from certain federal laws, like the Gun-Free School Zones Act. But outside of that, this bill would target folks traveling into Virginia from those other Commonwealths or those other states. Other restrictions that we're seeing proposed, we've got, and of course the name here is not going to surprise you, we've got Karen Keys-Gamarra proposing a $500 tax on suppressors. Of course, the federal government just removed the tax on suppressors. Now they want to add in a tax at the state level here in Virginia on suppressors. Talk about making suppressors way too expensive. And as a kid, my ears were damaged by shooting without adequate hearing protection. I don't know why we would discourage people from having suppressors. We should want people to have suppressors. These are not the scary things that people make them out to be. You can still tell a firearm's being discharged. It just makes it so it's less likely to damage hearing. It's not like police are going to have no idea that shootings have occurred when shootings happen. Finally, another Helmer bill that we need to talk about. Delegate Helmer attacking the firearms industry as a whole. I call this the Put the Gun Industry Out of Business bill. This establishes civil liability, and the big thing this does, there's a federal law called the Protection of Lawful Commerce in Arms Act that helps protect gun stores and FFLs from sort of nuisance lawsuits. This bill creates an avenue for people to sue gun stores for nuisances that are created by weapons they sell, even if the weapons are criminally misused, or the items that they sell are like ammunition, scopes, optics, etc. If they're criminally misused in a way that creates a nuisance, and it was reasonably foreseeable that they might be used in that way, whoever's affected by it can sue the FFL, even if there was intervening criminal use in the meantime. And that is contrary to the way the law generally works in the United States of America. Generally speaking, if I sell something lawfully and it is criminally misused, I'm not responsible for that criminal misuse. Why are they doing this? Again, they want to put gun stores out of business, unfortunately. So this is just a quick summary. I'm sure there's going to be many other laws that get filed in this legislative session. Going to be lots more problems to discuss. And I think one of the best chances we have to head all of this off is to show up at Lobby Day in Virginia. Again, Martin Luther King Day coming up. Hope to see you January 19th. If you enjoyed this content, go ahead, hit subscribe for us. Until next time.